Hello, everyone. This is John Borkowski, and I'm a partner in Husch Blackwell's Education Group. Our Education Group is part of our Healthcare, Life Sciences, and Education Strategic Business Unit. And within that strategic business unit, I'm also part of our newly formed Academic Medical Center initiative. On behalf of the firm and our Academic Medical Center initiative, we're very excited to have you participating in today's discussion about sexual misconduct in academic medical programs and the related legal issues. As always in our regular series of webinars, we'll be providing general information that should not be construed as legal advice. As will become clear during the discussion today, not only does any legal advice require a detailed analysis of the facts and circumstances surrounding a particular situation, but also in this area in particular, the law varies somewhat between jurisdictions, and the position of federal agencies on the appropriate interpretation of the applicable law is itself in flux. Before we begin, I'd like to cover a few housekeeping items. At the bottom of your audience console are multiple application icons for your use during the program today. I'd like to take a few moments to highlight a few of the key icons for you. If you have any questions during the webcast, please submit your question via the question box. We'll try to answer all of your questions during the webcast today, but if a fuller answer is needed or we run out of time, we'll try to answer it later via email. We truly appreciate audience participation, and we encourage you to submit questions at any time during the program. If you have any technical difficulty, please click on the Help icon. It has a question mark and provides information regarding common technical issues. A copy of today's slide deck is available in the Resource List icon. That icon looks like a folder at the bottom of your screen. The program has been approved for Illinois, Indiana, Iowa, Missouri, Nebraska, Tennessee, and Texas continuing legal education credit. Colorado and Wisconsin credit applications are pending. To report your hours in Illinois, Indiana, Nebraska, Tennessee, or Texas, click on the CLE widget at the bottom of your screen and complete the questions. A recording of the webcast will be available tomorrow for watching and sharing. Once available, a link to the recording will be emailed to you along with a certificate of attendance. Joining me today are Karen Cortu and Alex Rushing, also members of the firm's Education Group. Karen advises public and private institutions of higher education on a wide range of matters, including faculty, student, and employee matters, investigations, governance questions, and litigation. Her experience in higher education includes issues arising under Title IX of the Education Amendments Act of 1972, the Violence Against Women Act, Title VII of the Civil Rights Act, the Clery Act, and other federal and state laws and regulations. Alex Rushing counsels K-12 and higher education clients on investigations, litigation, and compliance matters, similarly arising in a wide range of civil rights and education funding issues. These include Title IX, Title IV, IDEA, Section 504 of the Rehabilitation Act, ADA issues, and FERPA issues as well. So with that, let's take a look at our agenda for today. When we talk about the issue of sexual misconduct in terms of federal law, one of the key federal laws is Title IX, and that's going to be our focus today. I will start out by doing a brief overview of Title IX, and then I will turn it over to Karen to talk about the tricky issue of the application of Title IX to academic medical programs. We'll then talk about policies and procedures and finish by talking about the shifting approach to these legal issues. So Title IX is the basic federal law that prohibits sex discrimination in educational programs or activities that receive federal financial funds. One of the principal architects of Title IX passed away this week, Senator Birch Bayh, and this was one of the things that right through the end of his life he put at the head of the accomplishments that he was a part of. Traditionally, institutions of higher education themselves have been the main ones that have had heavy focus on Title IX issues. Initially, a lot of the focus of Title IX was on equity in athletics, but beginning really around 2011, with some federal guidance from the Department of Education, Title IX in the area of sexual misconduct, sexual harassment, sexual violence, really became a big focus for colleges and universities. It got much more attention, and these federal regulations really pushed colleges and universities to put structures and systems in place to do a better job of addressing sexual misconduct, investigating, remediating sexual misconduct on campus. And it's been a huge focus for colleges and universities since 2011. To a lesser degree, K-12 school districts, they're also recipients of federal funds, and they've focused on this, but a lot of the work in the Title IX space has been done by colleges and universities. And at its core, what Title IX does is prohibit discrimination on the basis of sex to recipients of federal funds. So as I mentioned, that would apply to public school districts that receive funds. It would apply to colleges and universities that get student aid funds. But it would also apply to other recipients of federal funds who receive Medicare payments, who perhaps receive research grants, because Congress has the power under Article 1, Section 8 of the Constitution to put conditions on the spending of federal resources. And that is effectively what Title IX does. If you're going to operate an education program and you're going to use federal funds doing that, then Title IX prohibits you from discriminating on the basis of sex. Now, as I said, since 2011, there have been just very detailed rules that the Department of Education has put in place involving how colleges and universities and other recipients of federal funds have to address allegations of sexual misconduct. What do they have to do? They have to have a Title IX coordinator. They have to protect alleged victims. They have to conduct investigations. And there are detailed requirements around how all of that has to be done. The complicating factor here today is that there are proposed regulations that the Trump administration just came out with at the end of last year that are still pending. The comment period ended. There were thousands and thousands of comments on these regulations. And they would change to a detailed degree the regulations that govern this. And so the systems that are already in place at a lot of educational institutions are likely sometime this summer or next fall, when the regulations become final, are going to have to be modified in some significant respects. So we're not going to go into detail about that. We've done another webinar recently on the proposed regulations. But just as you think about this problem of sexual misconduct in the medical center environment, just be aware that the requirements are out there now are likely going to be changed to some degree. Let's talk a little bit about what we mean by sexual misconduct, or more precisely, what constitutes sexual misconduct under Title IX that institutions that receive federal funds and operate educational programs and activities have to be aware of and have to respond to. There are several different things that can constitute sexual misconduct. Sex discrimination is one such thing. There are really many kinds of sex discrimination It's not just sort of the quid pro quo type sexual discrimination. There's also a hostile environment sexual discrimination, and all of those things are prohibited. Sexual harassment, obviously, is prohibited by Title IX, and sexual harassment constitutes conduct that is severe, pervasive, but that impacts students' access to an educational program or ability to get the benefits of the educational program because of their sex. It obviously would include things like sexual violence. It includes pregnancy discrimination, gender stereotyping. And another thing that a lot of institutions sometimes forget about, and that is increasingly a part of complaints, is retaliation. That is, if someone comes forward with a claim of sexual misconduct or sex discrimination of any kind, an institution cannot retaliate against that person, even if it turns out that they conclude that the allegation was unfounded. They have a right to bring these claims forward, and you can't retaliate because an alleged victim brings a claim. There are ongoing questions about sexual orientation and whether Title IX prohibits discrimination on the basis of sexual orientation or, for that matter, on the basis of gender identity or transgender status. And the Supreme Court has a couple times ducked the opportunity to decide this issue definitively, and so you have different rulings in different federal circuits. I'm in the Seventh Circuit, which covers Indiana and Illinois, and in the Seventh Circuit has concluded that discrimination on the basis of sexual orientation is inherently discrimination on the basis of sex and is therefore prohibited by Title IX. And so, but different federal circuits have resolved this issue differently. And so when you look at a question of alleged discrimination or harassment based on sexual orientation or gender identity or transgender status, you need to be aware, at least until the Supreme Court clarifies the law in this area or Congress does, you need to be aware of what the law is in your particular jurisdiction. So I'd like to pause at this point and ask a poll question. I'd like to know, has your institution had a sex discrimination claim under Title IX in the last 5 years? We've put three possible responses here. Yes, you've had an OCR complaint. That would be a complaint filed with the Office for Civil Rights of the Department of Education. Or perhaps you've had a claim brought in federal or state court under Title IX. And the third possible response is no, you haven't had any Title IX claims brought against you in the past 5 years. We'd just like to get a sense of where the audience is on this issue and how much in this era of the Me Too movement these complaints have affected your institutions. So let's take a moment to answer that, and then I will take a look at the responses here. So more than half of you have had either an OCR complaint or litigation in the past 5 years, and that's very consistent with what we've seen with our clients, that this is a very hot area, and it's a very common problem. I think it's been a common problem for a long time, but it's one I think that today more and more victims of sexual misconduct or sex discrimination are bringing those claims forward. And in that environment, I think it's particularly important that you all pay close attention to this issue. And with that, I will turn it over to Karen Cortu to talk about sexual misconduct in academic medical programs in particular. Karen?
Thanks, John, and greetings everyone from Chicago. I'm happy to discuss sexual misconduct in academic medical programs. Not happy that it happens, but happy to report that the culture in academic medical programs seems to be shifting along with pockets of corporate and popular culture that we've observed. What has been traditionally a somewhat more hierarchical Culture, at least in some areas, now seems to be including more voices, and that also leads to more awareness and more reporting of issues related to sexual-based discrimination. In fact, reports indicate that as many as 50% of women in academic medical programs have experienced at least one instance of sexual harassment. And there are many reports of sexual violence, but we know that those types of incidents tend to be underreported. In addition, cultural surveys are suggesting that discriminatory cultures in academic medical programs and research have persisted, even though we believe they may be on their way out, if slowly. So how do we shift away from that culture if it exists at our institutions? And one way we see programs doing this is through focusing on Title IX compliance. The goals of the compliance are not only to limit exposure and risk, but also to protect your community, provide clear pathways that would be for reporting misconduct and discrimination, investigating reports, and addressing any type of cultural or incidents of discriminatory conduct that we become aware of. And the best practices for Title IX framework, which Alex will discuss in a few minutes, can provide a helpful structure for focusing on sexual non-discrimination. It can also complement other programming efforts toward inclusion and non-discrimination that are already underway in your academic medical program and provide signals to your institutional community that it's a priority. So the question for us today, at least for my segment, is does Title IX apply to your academic medical program? It certainly doesn't apply to every academic medical program, and as we'll discuss, frustratingly, whether Title IX applies may not be perfectly clear based on the limited authority that exists. But let's discuss that authority and how to determine whether Title IX applies to your institution or academic medical programs that you know. First of all, what are we talking about when we refer to academic medical programs? For today's purposes, we're going to use a broad definition. An academic medical program is an institution with residencies, graduate medical education, nursing rotations, postdoctoral programs, internships, visiting students, really anything you can think of that might fall under that umbrella is what we're trying to address today. Of course, the most obvious example would be a medical school or a nursing school, any kind of purely educational program like that, or a program at a typical educational institution like a college or a university. Often, though, these programs don't take place at traditional educational institutions. You can think about a standalone hospital or a clinic that brings in interns for limited periods of time or for limited purposes. We also know that student health centers, by their own definition, are not necessarily part of this just because they are student health centers. Where a program is within a college or university, then Title IX applies to all of the operations of the institution. So if you're listening from a college or a university, you are subject to Title IX across the board. But for others who might be listening from a hospital or a corporation that has healthcare applications, Title IX applies to, and this is the key language, educational programs and activities. So let's explore what on earth that means. At educational institutions, that's pretty much all operations, as we covered, but everywhere else, it's going to be a more nuanced analysis. We can think about it geographically to some extent. Educational programs and activities are generally understood to be all educational programs and activities wherever there's sex-based misconduct or conduct impacting the ability to participate But new guidance and regulations leave campus conduct that's not a part of educational programming and activities an open question. And who do we consider to be part of our institutional communities for purposes of this analysis? In other words, who are our potential complainants or respondents with respect to sexual misconduct? Well, these would be students, trainees, faculty, employees, job applicants, volunteers, third-party visitors, and really any learner who's in our environment. To help us figure out whether Title IX applies to a given institution, we wanted you to be aware of this resource. It's long and it's esoteric, but it is fairly clear. The link shown here to the U.S. Department of Justice Title IX Legal Manual, this particular link will take you straight to Section 7, which relates to enforcement, and that's important too. But we recommend starting actually with Section 3, which is on the scope of coverage. Now, we know that Title IX prohibits any entity that receives federal financial assistance from discriminating against individuals on the basis of sex in education programs or activities. Federal financial assistance usually means dollars, money, but it can be non-monetary as well, such as think of a subsidy or advantage terms for a transaction. More often, though, we encounter this in the context of scholarships, loans, grants, wages, payments to or on behalf of students. But it would also cover something like if the government loaned out researchers for a particular purpose to your institution. And this manual actually gives us sort of a helpful data point with an example. It says that if a private hospital corporation receives federal financial assistance to support the emergency rooms at that hospital, does Title IX apply? The department says that Title IX applies only to the students and employees of any educational programs operated by the hospital, if any. What's demanded here is a very fact-specific inquiry, and that's what makes the case law we're going to discuss, so important. Please note, though, before we get into the cases themselves, in case you're hoping to find yourself a loophole out of Title IX, out of the scope of Title IX, almost all of the guidance and the case law is consistent that we should be interpreting the scope of Title IX broadly because it is a non-discrimination statute. So if you're not sure whether it applies, you may want to conduct that analysis with an eye toward a broad definition. The leading case in this area is called Doe versus Mercy Catholic Medical Center. It's a Third Circuit case, and it's relatively recent from 2017. And I'll give you a little bit of background about it and why it matters, but also its limitations. So you're now familiar with the language we need to interpret. What was at issue here was whether Title IX applied to a particular educational program that was run out of a non-educational institution, Mercy Catholic Medical Center. Mercy Catholic was a private teaching hospital in Philadelphia that happened to operate a residency program. So is it a traditional educational institution such that all of its activities are covered by Title IX? No. But did it receive federal financial assistance? Yes, at the very least in the form of Medicare payments. It also had an affiliation with Drexel University Medical School, and of course Drexel is a traditional educational institution whose activities would be covered by Title IX. So in this case, the plaintiff, or the complainant, was a diagnostic radiology resident. She did things we expect many residents to do. She attended lectures by faculty, attended case presentations, sat for exams, etc. And she received unwanted sexual attention from who else but the residency director. When she tried to clear the air that she wanted the relationship to remain professional, it got worse and his overtures intensified. Plaintiff complained to HR, but was not satisfied because HR did not provide her much relief. And ultimately, plaintiff was dismissed and sued under Title IX and some state statutes. The district court dismissed her case, finding that Title IX did not apply to the hospital, and then the Third Circuit took it up, calling it a question of first impression, which of course it is. The Third Circuit considered various approaches to interpreting that language, educational program or activity, and ultimately determined that Title IX did apply. And what they said there was instructive to us, particularly because there's so little other precedent out there for us to rely on. The Third Circuit in Doe versus Mercy Catholic said that Title IX can apply outside of the traditional education context. And what we've gleaned from it is that organizations should expect Title IX to apply if two elements are met. Number one, that an education or training program is provided. That would be Jane Doe's residency program in this case. And two, that the program is operated by a recipient of federal funds from participating agencies, which we know was also the case. The Mercy Catholic decision also identified several other factors that could support a finding that a program or activity is educational in nature. For example, the program is incrementally structured through a particular course of study or training, or the program allows participants to earn a degree or diploma or qualify for certification, or that the program provides instructors, exams, an evaluation process or grades, or accepts tuition. And finally, that the entities offering, accrediting, or otherwise regulating a program hold it out as educational in nature. There have been a couple of cases since Doe versus Mercy Catholic that have taken up similar questions. For example, in Rossley versus Drake University, which was a district court case in the Southern District of Iowa last year, that court reinforced the principle underlying Doe versus Mercy Hospital, which was that Title IX applies to organizations other than educational institutions based on whether that particular program or activity at issue was an education program or activity, and whether the plaintiff was a participant in that program or activity. There's also another more recent case, just from January of this year, called Jackson versus Trustees of the University of Pennsylvania, in which the court found there were insufficient allegations of an affiliation with an academic institution. They seized on the fact that in Doe versus Mercy Hospital, one of the facts that led the court to find that Title IX applied was the fact of the affiliation between Mercy Hospital and Drexel University, an education institution. There's another complication that we should keep in mind here. In Mercy Catholic, the court considered and rejected the argument that Title IX claims were precluded because the plaintiff could have brought her claim under Title VII. In other words, the plaintiff could have said, as a medical resident, I'm an employee of this hospital, and therefore, to the extent I experience discrimination, I can find recourse by suing under Title VII, by going through the EEOC. Here in Chicago, because we're under Seventh Circuit precedent, Seventh Circuit has said that Title VII is in fact the exclusive remedy for this sort of claim, at least for now. So if you are outside of the Seventh Circuit and outside of the Third Circuit, what should you think about? You should figure out whether your circuit has weighed in on whether your plaintiff or complainant could be considered an employee, and also whether your circuit has weighed in on whether Title VII precludes a plaintiff from bringing other claims, for example, under Title IX. So here we have another poll question. We're interested to understand, based on what you now know, do you think that your institution offers any programming that could be considered an educational program for purposes of Title IX? In other words, do you think you might come under the auspices of Title IX and you better make sure that your compliance program is up to snuff? I'll give you a chance to answer likely, unlikely, or I don't know. Let's take a moment to answer that poll, please. Now, before we reveal the results, I should say that if you are about to tell me that it's likely you have educational programming, Alex is about to offer some helpful and practical information about Title IX compliance. If you find that it's unlikely that your institution or company has educational programming, then consider whether your institution might benefit from voluntarily adopting any aspects of what Alex is about to talk about. Also note that you want to be careful before making the determination that you don't have an educational program. Some of our clients are so decentralized that they may not even know exactly what programming is happening where. For example, whether they have a site that does accept an intern from a local college. So you might ask yourself, am I sure I know all the programs that are happening? And if so, are any of them educational? And finally, for those who are about to tell me, I don't know, you're in good company. I suspect that will be many of us. So what we would recommend is that you examine your programs, look into your affiliations, your internships, all of your programming, talk to your business folks, and also you probably know whether you receive federal financial assistance, but if not, you could shore up that answer as well. Now let's see what our poll has revealed. Aha. So maybe this is a self-selection issue. Most of us, 87%, say that it's likely we have educational programs or activities taking place in our auspices. And maybe that's why you called into this webinar today, so that makes sense. But in any event, I hope you'll listen with interest to what you need to be thinking about from a Title IX perspective. Now there's one more case we should discuss before we move on. Here it is. It's called Doe versus Prairie View A&M University. Right away, you probably noticed that the defendant here is a university, which means it's a traditional educational institution. Title IX is going to apply across the board to the activities of that institution. The question in this case was whether this was just an employment discrimination claim, and this was a case in which a student alleged that in the course of her work at a university research center, her supervisor sexually harassed her. And the reason we bring it up is because the court analogized to cases concerning medical residents, including Mercy Catholic, in holding that the Title IX claim was viable because the student had sufficiently alleged that she was not only a student at the time of the sexual harassment, but also that her job at the research center was in furtherance of her academic studies. So the court said no, this was not just an employment discrimination claim, a Title VII claim, for example. This was also potentially cognizable under Title IX. Finally, we wanted to let you know about one other issue that's sort of percolating for those of us who do institutional research. We're hearing chatter and seeing some action within research granting agencies that we think will lead to more rigorous Title IX and other enforcement mechanisms surrounding sexual misconduct in federally sponsored research. For example, at the end of February, the NIH actually apologized for its failure to address sexual harassment in research programs, surprising many. Also, the National Science Foundation in September 2018 added a term and condition called the notification requirement regarding findings of sexual harassment, other forms of harassment, or sexual assault. And this new term and condition requires that awardee organizations must notify the NSF of any findings of sexual harassment or sexual assault or other harassment regarding a principal investigator or a co-PI on a federally funded grant through the NSF. That's effective October 22nd, 2018, so it's already here. And something that we all, keep in mind, particularly as we're investigating reports, that we will have a notification requirement under our agreements with the National Science Foundation under certain circumstances. So I urge you to look into that if that might be pertinent to your institution. And now I think Alex will educate us a little bit on what we can do to make sure that we are Title IX compliant and using our best practices. Over to you, Alex.
Thank you, Karen. It's great to be part of this wonderful presentation on a really important topic, and great to see so many folks from all different areas, especially the St. Louis folks on the line. That's where I am right now. So this slide currently talks about what the Department of Education has issued regarding its guidance and using it sort of as a guidepost. It's different than a statute or a regulation or even case law that's binding. Obviously this is guidance, but we would strongly emphasize that that guidance be followed, especially for those of you who that guidance has been interpreted in your specific states and jurisdictions. And so the Department of Education's guidance doesn't expressly define expectations in this area for sexual misconduct for federal funds recipients without standalone educational institutions. But pending additional regulation guidance from other agencies, we do suggest that the Department of Ed guidance related to educational programs subject to Title IX be something that you certainly all take a look at. Now, several of the factors that contribute to this recommendation are the following: a single comprehensive response system for any sexual misconduct in all educational programs. That will promote clarity of understanding and of process. Also, healthcare institutions often have a standalone educational institution to which the Department of Ed's guidance would certainly apply: graduate programs, medical schools, nursing schools, and the like. Also, culture shifts in academic and public expectations are certainly calling for more formal processes for addressing sexual misconduct, which John and Karen both talked about during their pieces as it relates to sort of outside of the traditional school scenarios and the Me Too movement and that's impact throughout the nation. And then similarly, where courts allow Title IX lawsuits regarding sexual misconduct occurring in educational programs outside of the educational institutions, institutions providing the procedures and protections of the Department of Ed's guidance will be in a position to prevail on the ultimate question in those types of cases. So with that in mind, we're going to take a look at some of the basic obligations that the Department of Ed has put forward so that we can sort of get into the little bit of the nuts and bolts regarding what your obligations are, since such a strong group of you felt that your institution and your center Title IX applies to. So on this slide, you'll see several of the basics related to your Title IX obligations related to issuing a notice of non-discrimination, designating a Title IX coordinator, having grievance procedures that are in place and that are also published and available for your students and for your population, and making sure that there's a prompt and equitable resolution of those complaints, not necessarily within a certain time period. It used to be within a very designated time period. It had to be within 60 days that it was resolved. That's no longer a requirement. And then finally, the piece that I would highlight is the training for your administrators and community educational programs. Training has really been where I've seen in my practice the biggest key in this area. Is a lot of times it is a lack of understanding and a lack of knowledge, and so making sure that your folks understand that information is really the key. So going through different types of trainings, in person, via video, all the different methods. Maybe that's my former public school teacher hat on, but trying to influence all different types of populations in the way that all different types of people learn is really important with that training piece. So on this next slide, you'll see some of the other elements that really have to be included should Title IX apply to you based on those factors that Karen outlined earlier, whether you're an educational program or not. Some of the things I want to make sure that I highlight relate to the notice piece. This is one where, as outside counsel, we get so many questions related to notice requirements and how to properly notify parties, and so I want to make sure to highlight that here. It needs to be very specific as to the complainant, the location, time, and alleged misconduct. So it has to be something more than just that typical non-consensual sexual activity, especially where the complainant says some activity was consensual. I highlight that because a lot of our institutions and throughout the media we've seen several different schools and other bodies where Title IX applies to it sort of have a broad notice that didn't discuss that who, what, where, when, why piece. And that the Department of Ed, especially under this administration, has identified as not being compliant. And so being certain that you have a very thorough notice that goes out to your parties so that they're aware of what the alleged conduct is and are able to respond to the allegations that are before you. Amnesty is another issue that you'll see on this slide that I want to highlight. Now, this can be a really tough situation in the healthcare context, where the use of drugs or alcohol can impact safety and patient care and the like. So some of the things to consider are consider having it, consider applying it only to complainants or witnesses, consider requiring that the use not implicate safety, consider leaving a possibility of counseling open, or potentially expressly stating that your institution will still honor reporting obligations, so to nursing or medical boards and research institutions. Those are sort of the variety of ways that you can go about sort of that amnesty piece. And the final issue that I'll bring up on this slide to highlight is the privacy versus confidentiality issue. The need for explaining this is particularly acute in academic medical programs where we have reporting obligations to outside entities, additional involvement of minors, as an example in children's hospitals, obviously, and healthcare provider privileges, HIPAA, can cause confusion about what may and may not be kept confidential. So it's really important that those pieces be highlighted within your policies and procedures. So the next slide discusses...
Alex, this is John. We've had an interesting question come in that I just wanted to see what your viewpoint is, if I could interrupt you for a sec.
Absolutely.
So, if we start paying a lot of attention to all of these requirements and we train people and we publicize our policies and do all of this, even if it's not completely clear that other agencies besides the Department of Ed require this, isn't that just going to drive up the number of complaints that we have to deal with?
I would not necessarily say that that's true. No, I think that it would instead make the culture of your institution that much stronger. We've seen several of our clients who are not educational institutions, who don't operate as an educational program, still adopt some of these policies and procedure elements because they are really a best practice. And given the culture and the environment that now exists related to sexual harassment and sexual misconduct, this is certainly an area that, even though some of these requirements are very Department of Education focused, there are also some best practices to consider even if Title IX doesn't apply to you. So I would suggest that even if you were one of those, I think it was about 5% of folks that said that they do not likely think that this applies to them, I would still recommend taking a look and doing a deep dive into what areas within these policies and procedures and within this framework that you could maybe adopt within your institution to really provide that culture of understanding and that culture of open reporting, and one where people feel safe. I think that's really the critical piece, not only on college campuses, but in our academic medical schools as well. So I'll move on to the framework piece related to those policies and procedures, and you'll see that this deals with standard of evidence, that it's a fair and equitable, reliable investigation and is impartial, and that the timeline for which responding to the complaint and conducting that investigation is done reasonably. You'll see that language is different from what I described earlier. The Department of Ed used to have a very strict timeline, and now they work under this reasonableness timeline, which has helped a lot of our clients meet their obligations much more efficiently and effectively. So in terms of the standard, most institutions, based on prior guidance, are using a preponderance of evidence standard, so that's that more likely than not. But the guidance does allow a clear and convincing standard. This is a higher standard than that preponderance more likely than not standard. So under that higher standard, that's what the current guidance permits. We haven't seen that utilized a lot since that new guidance came out, but certainly it is something that's permitted under the new guidance. Something to make sure that you're aware of, and sort of an additional nuance that we won't really go into here, is if you're using that clear and convincing standard for sexual misconduct, you have to use a higher standard for all misconduct. And that's really why I think a lot of the folks aren't using this higher standard, is because you have to use it in all types of misconduct, and they typically have that preponderance or more likely than not standard related to other types of misconduct. The proposed regulations would allow a higher standard for just sexual misconduct in light of heightened consequences. But again, those are just proposed regulations right now. Those have not yet gone into effect, and so we will see once they go into effect if that becomes part of the final rulemaking. Another piece I want to highlight here is related to informal resolutions. I've seen in my practice a really big increase in informal resolutions as of late. We suggest an explanation of, one, what the status of the case is after informal resolution, that it can be reopened, when it can be reopened, under what circumstances, and then also having the records maintained or shared, making sure that if you are part of that informal resolution process, make sure you consider those two pieces. And then the final piece on this slide that I'll touch on relates to the appeal process. We assist a lot of our clients in this part, especially the appellate officers who don't have sort of the boots on the ground perspective related to Title IX investigations. They're not the ones doing the investigations. They're just the overseeing body that handles the appeal process. So I'm handling several of those situations right now. And what I'll report is appeals are not required. That's something that has changed under this administration. But if it is allowed by your institution, then it has to be allowed for both parties. Both parties should have the opportunity to appeal. And so making sure that your policies are really tight on that issue is also really important, because that's been a distinction in the last couple of years that's changed. So the next piece to go over after we discuss the framework is now the process. Going through notice, making sure that there's an equal procedural rights and informal resolution, and then making sure that you draft the report for the parties to be able to comment on. I'll highlight for a moment that piece, that when you're drafting that initial investigative report, allowing the parties to review what sort of the factual background is, what individuals have reported, and having an opportunity for them to comment on that has really been important and imperative in drafting our investigative reports. I do several Title IX investigations as part of my practice, and so this has been a shift in the last couple of years to allowing that piece to have the students go back and look at the investigative report, whereas we would typically just send out a final version. And there have been times where it's been very helpful to have the parties look back at the reports, because either a transcript wasn't transcribed correctly, or note-taking wasn't done properly, or additional evidence needed to be put forward that perhaps the party didn't think was important, but then upon reading something, new evidence came about that was important. And so it's very critical to make sure that you allow those reports to be viewed and commented by the parties as well. And like I said, I touched on that appeal piece on the previous slide. So we'll move on to the resolution phase, which is usually our client's favorite piece when it can finally get resolved. We've seen a trend that is away from a single fact investigator, where there's a single investigator who's finding the facts, determining the violation, imposing discipline. Typically, we'll see a dual investigator model that investigates and makes a recommendation regarding the facts that they found and the determination of a violation, but that ultimately there's a different type of decision maker. Recent case law has actually said that a hearing is probably the best practice. And so make sure that you look in your jurisdiction, if that's one of the jurisdictions that you're a part of, if hearings are something that you all should be doing or not. That's very jurisdictional dependent right now. One thing to note too is in those proposed regulations that we touched on earlier, there is a call for hearing as well as cross-examination by an advisor. That's a piece that we have not typically seen before, as well as providing advisors It does stop short of requiring a panel, but it would require a hearing officer be separate from an investigator. So that's something that we'll see once that final rulemaking comes out, where our schools go with that information and how they change some of their policies, procedures, and practices, because many of our clients do not utilize that process. So then the next slide I will touch on relates to the definitions piece. Definitions that need to be outlined within your policies and procedures, or at least to consider outlining. Something that I'll highlight that, all of these that are on your slide are incredibly important, but I'll only highlight a couple that I see typically the biggest issues with, at least in my practice. So I'll highlight first the consent piece. This is an issue that arises really frequently in academic medical centers, and it's whether by virtue of a faculty member's research, primary investigators, or clinical supervisors' level of control over a learner's future, relationships between the two can never be consensual. There are arguments, obviously, on both sides of this issue, where those involved are adults, but there is also a substantial power differential, so it's really important to pay attention to that. For this, we suggest that institutions consider this issue not necessarily that you directly address it. As you develop your Title IX systems, it's an issue that can be addressed in a consensual relationship policy, and that's really where we see a better fit for that particular piece. And then related to educational programs and activities, this isn't typically defined at educational institutions. I know Karen went through a really deep dive into that 3-factor analysis related to what an educational program or activity is. But this isn't really something that we see defined where all programs and activities are covered. You may need a definition at a healthcare institution where you have plenty of operations that are not educational, so that may be different for this particular audience. And you may want sexual misconduct in those operations obviously handled differently. So that's really something that should be considered at your institution. The final piece that I'll highlight relates to student and the definition of what that is. Again, here, this may be an obvious definition at our client that are colleges and universities, but may not be as obvious at academic medical centers. So it's really important that for those of you who are on the line to understand where you fit in that spectrum. And so that brings us to our final poll question, and this one is more of a checking of understanding. I mentioned earlier I used to be a teacher, so for me this allows me to put my teacher hat back on and see who on the line is listening to what we're talking about. So the question is, in terms of notifying the respondent, what is needed within the notification letter? A, location, time, and alleged misconduct. B, specifics about the complainant. C, all of the above. Or D, none of the above. And we'll allow a couple seconds for those of you to be able to answer that question. I see answers are slowly trickling in, so I'll give a little bit more time to make sure that everyone on the line gets that chance to click the submit button. We're also getting a lot of wonderful questions on our question and answer on the bottom tool set there, so I'll make sure to get to some of those as we continue on in the program. A couple of them will hopefully be addressed in the next coming slides. So I will turn to our results here. So we had about 30% of people say location, time, and alleged misconduct is required. We had 1% of folks say that only specifics about the complainant are required. 60% of you said all of the above, and about 10% of you said none of the above. So it looks like the majority of the audience was correct that all of the above are required: location, time, alleged misconduct, and information related to the complainant. Again, this has been a shift in prior notification. Some folks were not including information regarding even who the complainant was. That is certainly not something that this Department of Education condones, and in fact strongly recommends the opposite direction in saying that you must let the respondent know who the complainant is in order for them to be able to respond to the specific allegation. So one question that I want to make sure I get to relates to something that we've certainly all on the phone can probably relate to. We've heard it before. You've heard probably nurses say a million times that putting up with pinches or flirting from elderly patients and things like that are just part of the job. We've heard some of this language before, but I just know that that's part of my job. But something that I really caution you is, if you are subject to Title IX under the Department of Ed, this is probably not the best approach to be taking. the bottom line is that you all have to take these complaints seriously and do what you can to address them. You can certainly help students and employees understand that there is probably some touching associated with their job, depending on what their job is, such as that which occurs when moving a patient and things like that. But verbal abuse from those who are incapacitated, that's largely unavoidable in some instances, but that doesn't mean that we can't do things to address it. And some of the things that we typically suggest are having students work in pairs, work together so they're not alone, and offer alternative patient rotation options where possible, and then also admonishing patients. That's certainly something that we've seen take place and wouldn't hesitate on, because having that mantra of it's part of the job isn't something that we would recommend. And so I hope that answers that person's question. So we'll move on to the Clery Act and touch on that very briefly. As a side note, we often get questions about the Clery Act and how it applies to AMCs. The Clery Act applies to all U.S. colleges and universities where the healthcare entities are part of a larger university or share space with an institution like a nursing college. We see a lot of those in St. Louis. The university or college must analyze whether and how Clery applies to their healthcare operations, so how it relates to their crime statistic reporting, their annual security report, things like that, and being prepared to cooperate and work out with an appropriate agreement with your particular system that's in place. That brings us to VAWA, the Violence Against Women Act. And although this is an extension of Clery, institutions that are not bound by Clery may want to take a page out of VAWA when developing their sexual misconduct systems. Again, this sort of touches on that question, John, that you asked me earlier, is even if it doesn't apply to us, should we still consider it when we're developing our culture and our policies and procedures? And so VAWA should be applied by the university or college where such misconduct occurs in those type of programs or activities taking place in part of a hospital operation, so like a clinical, a residency program. And hospitals should consider the extent to which they want to extend VAWA provisions, cultural expectations, the evolving best practices, and the extension to domestic violence, dating violence, and stalking. It's really important to have some system in place, but may not be a full Title IX system that we've talked about earlier. And this brings us to our pregnancy leave policies. These come up a lot in academic medical programs where learners have to be present for clinical hours. We have cohort programs and shifts need to be covered, things like that. So for maternity and paternity leave, other than as an accommodation for pregnancy or childbirth, it's not required. But make sure you're aware of the fact that Title IX would prohibit sex discrimination in granting it. So consider whether appropriate to grant a non-medical leave to women but not to men. Be very cautious of that issue. The next piece that we'll touch on relates to affiliation agreements and some of the issues related to that. In these agreements, I'll highlight the notification provision as part of it, that colleges and universities should want to know about sexual misconduct their students and employees report to a hospital as having occurred in the hospital's programs and activities. And hospitals should want to know what colleges and universities to pass on the reports to related to college and university employees about alleged sexual misconduct occurring in the hospital operations. It's really important to make sure that that's spelled out within those affiliation agreements. And this slide touches on some of the additional considerations to be aware of. I'll allow all of you to peruse that in-depth checklist that you'll see on your slide in just a second. Something to make sure you're aware of is all these related policies, try to make sure that they work towards consistency together. Consider the interplay of your other disciplinary policies and procedures. Remember, I mentioned that clear and convincing standard earlier. If you're using it in Title IX, you've got to use it. If you're using it in your sexual misconduct investigations, you have to use it in your other investigations as well. And finally, I'll close with a shifting in approach. We're seeing a shift in approach away from terminating investigations where an accused has resigned or left. We're also seeing a shift away from confidentiality agreements. And so here are some of the, like I said, changes that we've seen over the last couple of years. Confidentiality agreements, we sometimes see offered to accused in return for voluntary departure. But again, in all of these situations, really be cautious because the tides have slowly been shifting. And with that, I will turn it over to John to close out our program.
Alex, thank you very much. We've had a number of questions come in that we're going to have to try to address later that really involve very particular circumstances that are very near the border of whether a particular institution would be covered by Title IX or not. And since we're out of time and since those questions are so fact-specific, we'll try to get back to you via email. We also had a request that we link our prior webinar on the proposed regulations that are currently being considered by the Department of Education, along with the comments to those, and we are looking into whether we can do that, and if we can, we will send that out to all attendees along with the recording of this webinar as well. And so with that, I'd just like to thank you for joining us today. We hope the information was helpful for you and your organization. If you've not already done so, please click on the survey icon that's at the bottom of your screen. You'll find there a short survey. If you could complete that, we would really appreciate it. Your feedback assists us in providing quality programs in the future. And just a reminder, this program has already been approved for Illinois, Indiana, Iowa, Missouri, Nebraska, Tennessee, and Texas continuing legal education credit. Colorado and Wisconsin credit requests are still pending. Finally, a recording of this webinar will be available tomorrow for watching and sharing. We hope to also provide a recording of our previous webinar, as I mentioned. Once available, a link to the recording will be emailed to you along with your certificate of attendance. This concludes our webinar today. Thank you very much for your participation.